Donald Trump is counting on Aileen Cannon to come in one more time. Come on, Judge Cannon, bail me out one more time when it comes to Mar-a-Lago, the Espionage Act, and obstruction of justice. Don't release Volume 2. Don't allow Pam Bondi, who doesn't want to release Volume 2 of the Mar-a-Lago report prepared by Jack Smith. Don't let the public see it. They've just filed new papers to encourage once again Aileen Cannon and remind Aileen Cannon of who appointed her to that job, and his name is Donald Trump. Jack Smith was the special counsel. He had 2 volumes at the closeout of his investigation, one related to the D.C. election interference case that was ultimately released through Judge Chutkan and by Merrick Garland, then the head of the Department of Justice. Volume 2 about Mar-a-Lago, remember that? The Espionage Act, the obstruction of justice that was alleged and indicted against Donald Trump in cooperation with Carlos de Oliveira, an IT worker, and Walt Nauta, his butler. That got buried by Judge Cannon, who found that Jack Smith, first judge in 200 years, found that a special attorney appointed by the Attorney General needed to be confirmed through the Senate, a position that they've completely flip-flopped on the Department of Justice currently, as they're appointing phony special attorneys all over the place, including Alina Habba, including Lindsay Halligan, including John Sarconi up in the Northern District of New York. But down in Florida, they're still arguing that Jack Smith is a so-called special counsel and triggering Aileen Cannon. Why does it sit with her? Because she has the file. And American Oversight and the Knight Institute, First Amendment type public interest groups, filed a case under the Freedom of Information Act to get Volume 2. All right? It was filed with the judge. She has it. Yes, there's a provision that says that the Attorney General at the time makes the decision. Merrick Garland left a love note for one of his many failings on the way out in before January, and he let the decision about Volume 2 be made by her, not by him. He should have released the file. There was nothing Aileen Cannon could do about it. It was with the Department of Justice. But since she had a copy, the argument goes, these First Amendment rights groups have a right on behalf of the public to get a copy of it. The 11th Circuit ruled about 3 weeks ago, that Aileen Cannon needs to make the ruling, that she'd been sitting on it for more than 90 days. Now that it's been revived, we have new filings by the puppet show that is the Southern District of Florida U.S. Attorney's Office, now run by a Trumper, used to be a military attorney named Jason Redding Quinones. Quinones was so bad as a prosecutor when he used to work in that office that he was effectively written up for poor performance. He now heads the office. So he's filing all sorts of papers to try to have the Trump administration intervene into the case on behalf of the Department of Justice to convince Aileen Cannon that she should block the release of Volume 2. All right, let's break it all down. You're on Wednesday on Legal AF. You might notice I've been traveling, but we got to cover these stories, and I'm happy to do it with you and for you here on Legal AF. These two groups, American Oversight and the Knight Institute, First Amendment groups, they realize, as we all do, that Volume 2 is stuck in Aileen Cannon's chambers. And so on behalf of us and under the Freedom of Information Act, they bring a case to get that information out and have it released to the media. The 11th Circuit tells Aileen Cannon, get off your backside and make the ruling. That leads to filings that are getting made now by the Trump administration. And what they're really relying on is an argument that they made, at least the co-defendants for Donald Trump made back in March during a status report, that, oh, well, it'll embarrass and it will shame and it will leave a black mark on the co-defendants here, even though they can't really be prosecuted because the statute of limitations is about to run and Trump's Department of Justice is not going to prosecute his co-conspirators. But they still argue, well, we'll be shamed and it's a one-sided presentation. Let me read to you from the language of what they're currently relying on in their new filing. You go back to a status report that was filed in March 14th. And what it says is that the Attorney General has not ordered the release of Volume 2, that Mr. Nauta and Mr. De Oliveira agreed that a desirable resolution is one that would avoid the task of dissecting Volume 2 of the unconstitutional special counsel's report to identify and seek protection of information. So they don't want to go through the report at all. And then they basically argue that the black mark over them is so great that the government should not be allowed, or these interest groups should not be allowed to obtain any of this information. And that the court should retain jurisdiction over the report's release and not release it at all. And ultimately, I guess, let the 11th Circuit decide on it. So they file this report about the privilege and the protections and the prejudice to Donald Trump's co-conspirators in their new filing. And the new filing, which just came out today, says Donald J. Trump respectfully submits this motion for leave to participate as an amicus curiae, meaning a friend of the court, in his individual capacity with respect to the motions to intervene. But these are filed by, very interesting, these are filed by and signed by lawyers of his, Kendra Wharton, that he hired at Wharton Law, some law firm I've never heard of, in West Palm Beach, as counsel for the president, Donald J. Trump. And what they're arguing is that none of this should be, and reminding Judge Cannon that Trump is effectively back in the case, and to get her to deny the lawsuit to release the volume 2 of the Mar-a-Lago special counsel's report, which means this is going to go up to the 11th Circuit ultimately. But I love that Donald Trump needs to come into the case in order to remind and warn Aileen Cannon. Aileen Cannon should disqualify and recuse herself from this case. She was shortlisted to be the Attorney General under Donald Trump. It was leaked out during the transition. He never denied it. She never saw a reason to recuse herself. How about the fact that you're on the short list to be his Attorney General if Pam Bondi ever gets bounced? How about that? And so you've got Bondi using her puppet in the Southern District of Florida, Jason Quinones, is the U.S. attorney, to run interference along with Donald Trump's private lawyers to try to stop the release of the file. You know that file is lousy with information that shows how dirty Donald Trump's conduct was. We know most of it from the indictment of Mar-a-Lago. You know, the attempts to erase the video, change the locks, move the documents, hide them from Donald Trump's attorneys, his own attorneys, hide them from the government. We know all that was going on, but we want to see the report. There's another major failing, though, of Merrick Garland, just on the way out of this YouTube hot take for you, is that he should have released that report right before he left office. He should not have left it to Pam Bondi. We knew what was going to happen, and now it's happened. So we'll continue to report on it. Thanks for being here on Wednesdays on Legal AF. Hit the free subscribe button. There's still time left on the clock. I have a special birthday sale going on Legal AF Substack. You can come over and for a third off, become a member on an annual membership for my birthday. Head over to Legal AF Substack and become a member. That's what keeps us on the air. That's what pays for reporting and commentary like this. So until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touches Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok firm, fighting for your justice every step of the way.